As part of your proxy statement filed with the SEC, you will disclose the involvement of directors, director nominees, and executive officers in certain types of legal proceedings over the past 10 years. Today on Zippy Point. I'm Brock Romanek, and I'm a big fan of use. Trim down some of the basics. Item 7B of Schedule 14A refers to Item 401 of Regulation SK, specifically 401F. Part 1, Item 10 of Form 10K does as well, but the proxy disclosure typically is incorporated by reference into the 10K. Note that I have separate Vid-Guides regarding disclosures of certain biographical information about directors, director nominees and executive officers, and director nominee qualifications. Links to those videos are beneath this video. So this is a tricky area. This area is a bear. As you would expect, most legal proceedings disclosures are highly sensitive because it's personal to the director or officer involved. But this is exactly why the purpose of this disclosure, because people want to know about who your directors and executive officers are. And this, if they're involved in certain types of legal proceedings, that might implicate their integrity and their character. Anyway, so there's a number of gray areas interpreting this section, item 405F, due to the sensitivity. And that's why there's more case law in this area than compared to other parts of the proxy, because more companies are willing to take positions that frankly push the envelope. Who is covered? Item 401F requires disclosure of all the company's directors, director nominees, and executive officers. Under Instruction 4 of Item 401F, disclosure is not required for directors whose term of office will not continue after the shareholders meeting to which the proxy relates. This area of disclosure is why, or should be why, some executive officers might not be so excited to be tapped as an executive officer for SEC filing purposes. 10-year look back. The proceedings captured by item 401F go back a long time, 10 years. Instruction 1 of item 401F specifies that the date of a reportable event is when a final order, judgment, or decree is entered, or the date on which any appeal right from preliminary orders, judgments, or decrees lapse. So by its terms, 401F may require disclosure of matters that might not have run the full course of the appeals process. Certain types of ongoing appeals will stave off disclosure, but not all. And the fact that there's an appeal outstanding is a mitigating circumstance that can be disclosed. It's not a reason that can support omission of the disclosure. What to disclose? Item 401F provides a list of 8 specific types of legal proceedings that, subject to a materiality qualifier, need to be disclosed. So you can read through 401F here in your own time, but it does include bankruptcy or receivership, violations of the securities laws, and other things that aren't criminal. Although it's rare for companies to voluntarily provide disclosure outside the list of 8 specific types of legal proceedings here, you may need to disclose things that are not on the list to avoid having a misleading proxy under the anti-fraud rule, Rule 14A9. Item 401F2 specifically excludes traffic violations and other minor offenses. The challenge is determining what is considered a minor offense. So this court interpretation is a little bit controversial because it illustrates that the threshold for minor offense is pretty low. 2 misdemeanor criminal offenses involving 2 small checks of $30 and $50 were deemed by the SEC to not be minor. So this compliance and disclosure interpretation emphasizes that the offenses in this case met the requisite materiality standard. In my opinion, it does bear on their integrity, and in fact, it might bear on their intelligence. If you're going to commit fraud, don't do it for 30 or 50 bucks. Anyways, item 401F includes a materiality qualifier, and it's more challenging than other materiality qualifiers because it states that you're looking at whether it's material to an evaluation of the ability or integrity of the director nominee, or executive officer. So you're not evaluating, the materiality standard is in terms of, the big assets, the whole company value. This is about that specific person. So as we reflect back on that compliance and disclosure interpretation, the nominal amounts of money that I made fun of, the 30 and 50 bucks, it was considered qualitatively material by the SEC staff because the person was committing fraud. Item 401F2 requires disclosure if the director nominee officer is a named subject of a pending criminal proceeding, meaning that if your insider is named in a pending criminal proceeding, you may need to disclose it even before the proceeding has been concluded. It's pending. A well-known case in this area is the Second Circuit's United States versus Matthews from way back in 1986. The director was a subject as opposed to a target of a grand jury investigation regarding a bribe conspiracy that wasn't disclosed in the proxy. And even though the grand jury didn't indict the director, he was prosecuted for making false and misleading statements in violation of the anti-fraud rule, the Rule 14A9, by failing to disclose his alleged involvement in the conspiracy. So over the years, there have been a number of cases, and if you have a situation on your hand that you're deciding whether disclosure is required, you're going to want to conduct some research, some legal research on litigation. You thought you got out of the whole case law stuff when you got out of law school and you got into this field, but you didn't. Mitigating circumstances. Instruction 3 of item 401F specifically states that relevant mitigating circumstances may be disclosed, which is kind of funny to me because you can always disclose voluntarily other things like mitigating circumstances. So the real reason for instruction 3, I think, is because it makes clear that just because you have mitigating circumstances doesn't serve to make an otherwise disclosable matter non-disclosable.